Um, Good afternoon, everybody. I am Max Melman, Professor of Law and Co-Director of the Law Medicine Center, and it's my pleasure to welcome you to our first Zaremski Forum for the 2020-2021 academic year. These forums are named after Miles and Elena Zaremski. Miles was a 1973 graduate of the law school, and he and his wife have generously endowed this series of lectures. And we're very grateful to them for doing this. Our presenter today is Professor Jessie Hill, who is the Judge Ben C. Green Professor of Law, also our Associate Dean for Research and Development. And her topic today, a subject that she is one of the great experts on, reproductive rights and the Roberts Court. Sorry. Jessie?
Thank you. Thank you, Max. And thanks, of course, to Miles Zaremski for supporting this lecture series. I'm really pleased to be here. I'm going to be talking about two key cases decided by the Roberts Court this term, one involving abortion and one involving contraception. And my plan is just to give you some background, context, and then explain what the court decided, and then hopefully touch a little bit on the implications. I want to talk for about probably 40 minutes, maybe 45, but I do want to be sure to leave some time for Q&A. So I'm not going to take up the whole time. This is approved, however, for CLE, and I am putting into the chat function right now what should be the link to the evaluation form for those of you who are seeking CLE credit. So you do need to complete that evaluation in order to get CLE credit. And I'll also be posting at the end of this lecture the activity code and the information that you need for CLE. And also, if you registered, you would have gotten an email about this as well. Okay, so just one other housekeeping matter before I'm gonna switch over to my PowerPoint, but just one other housekeeping matter is that, this is a webinar format. You're probably all familiar with this by now, but for those of you who might not be, you are all muted as attendees, and I can't see you. So if you have questions, please feel free to drop them into the Q&A box, which if you hover over the bottom of your screen, generally that's where you will find them. In the Q&A box, just type a question in, and I will probably most likely not answer during the presentation because I don't have a moderator, but I will endeavor to answer them at the end. In addition, if you have comments or questions, or like there's some kind of technical glitch I didn't perceive or something like that, you can put it in the chat box, and I will probably be able to see that. But in any case, please feel free to type questions during my presentation, and then I will just answer them at the end. Okay. So now I'm going to switch over to my PowerPoint. So just give me a second to share my screen here. And here we go. Here we go. Okay, so as I mentioned, there were two significant reproductive rights cases decided by the Supreme Court this past term, at the end of the term. One dealing with abortion, June Medical Services v. Russo, and the other dealing with contraception and the requirement to cover contraception in employer, in insurance plans, which was Little Sisters of the Poor v. Pennsylvania. Let's start with the abortion case. Okay, so to understand what the Supreme Court decided in the abortion case in June Medical Services v. Russo, we really have to get some background and go back to 2016 when the Supreme Court decided Whole Woman's Health v. Hellerstedt. So I'm going to spend a few minutes on Whole Woman's Health. In that case, the Supreme Court considered the constitutionality of a Texas law that required abortion providers to have admitting privileges at a local hospital. The Supreme Court struck down that requirement as an unconstitutional undue burden. And those words undue burden are like magic words. That's the test for whether an abortion restriction is unconstitutional. If it imposes a substantial obstacle to a patient's abortion access, then it is an unconstitutional undue burden. And the Supreme Court found in Whole Woman's Health that, in fact, the Texas law was an undue burden. And the reason for that is that the court said when you decide if something's an undue burden, you weigh the benefits of the law. So here, those benefits were supposed to be that they made abortion safer. However, the evidence showed that actually that admitting privileges actually bring no safety benefits. And then you weigh those burdens against the burdens of the law. And here in Whole Woman's Health, the admitting privileges requirement would close over 3/4 of Texas's 40 abortion clinics. So it would leave the state of Texas with only about 8 to 10 abortion clinics. Well, actually, that law combined with another law. The admitting privileges requirement alone would have closed about half the clinics. And then there was a second law, not relevant here, that would have closed another half. So, weighing that extreme burden of closing half the clinics in Texas against the negligible or zero safety benefits, the court saw this law as being an unconstitutional undue burden on abortion access. And in fact, it seems pretty clear. I can go in the Q&A into the reasons why these laws are basically just pretextual and bring no actual health or safety benefits. But on the whole, the reason the court basically saw through the sort of pretext of this law as being just a way to shut down abortion clinics and not bringing any meaningful benefits to the safety of abortion. Okay, so what else you need to know about Whole Woman's Health is here in the graphic at the bottom that this was a 5-3 decision in favor of Whole Woman's Health. This was at a time where Justice Scalia had died and not yet been replaced by Justice Gorsuch. So there were 3 conservatives in the dissent, Roberts, Thomas, and Alito. And then Justice Kennedy, who was the sort of middle of the court at that time, the swing vote, joined the 4 liberal justices to vote in favor of the clinics and to strike down the law. Okay, so Kennedy was still on the court at that time as well. As we know, of course, he was later replaced by Justice Kavanaugh. Okay, oops, let's see. Okay, so what did the court decide in June Medical Services v. Russo? Well, in June Medical Services v. Russo, the court considered an almost identical law out of Louisiana. Louisiana had passed this law requiring admitting privileges for abortion providers around the same time as Texas, actually, or shortly thereafter, before the Whole Woman's Health decision. But instead of just striking that law down in the light of the Whole Woman's Health decision, because it was essentially identical, the Fifth Circuit Court of Appeals actually upheld Louisiana's law and said that it was different in terms of its impact from the Texas law. Well, in June Medical Services, the Supreme Court disagreed and struck down the Louisiana law as well. And what that meant in Louisiana was that Louisiana had 3 abortion clinics and 5 abortion providers. Had the law gone into effect, it would have shut down 2 of the clinics and it would have left the state with only 1 physician to provide abortions. The breakdown was that Chief Justice Roberts joined the 4 liberals on the court to strike down the Louisiana law. And so there was the big question, I think, in folks' mind after the June Medical Services case was, is this a sign that Chief Justice Roberts is moving to the left? I don't think it is, for reasons I'm going to explain. I think that question maybe matters a little less today than it did last week when Justice Ginsburg was still on the court, but we can talk about that more in a moment. But I don't think that Chief Justice Roberts has shifted sides or is now a reliable sort of liberal vote. Okay, so what did the Supreme Court say in June Medical Services? Well, there were actually two issues, and I just want to touch on this first one for the sake of completeness. There were actually two issues in the case. The one was about the admitting privileges requirement, but I also first want to talk about this question of third-party standing. Third-party standing is the doctrine that allows abortion-providing physicians as well as clinics to raise the rights of their patients, to sue on behalf of their patients to challenge abortion restrictions. This is a very common practice. It has been for 40, 50 years in abortion cases. It's rare to be able to get an individual patient who is seeking an abortion to bring a federal lawsuit and challenge an abortion restriction. There are all kinds of practical obstacles to that. Because doctors and clinics generally face penalties under abortion restrictions, they are usually the ones to sue. But because they're raising the rights of their patients, not their own rights, it's their patients who have the abortion right, the 14th Amendment rights, this is considered what's called third-party standing. It's an exception to the usual standing doctrine. Well, what the Supreme Court said in June Medical Services is that doctors can sue on behalf of their patients. And for two reasons, really. One, the state of Louisiana had actually waived this standing argument by not raising it below. And also, secondly, because, as the court said, we have long permitted abortion providers to invoke the rights of their actual or potential patients, particularly where the abortion restriction regulates the providers. And there were actually 4 justices that completely signed on to this particular holding. So it's kind of uncontroversial in the sense that it's just upholding the status quo. Had the court gone, again, a decades-long status quo, had the court gone in the other direction, it would have been a potential bombshell and have huge implications for the ability to challenge abortion restrictions in court. As it stands, it was a pretty uncontroversial result. And Chief Justice Roberts joined the 4 liberals in that holding completely. Okay, then the other holding was that Louisiana's admitting privileges law for abortion providers is essentially identical to Texas's and is therefore unconstitutional. Louisiana's law, as I said, would have closed 2 of the 3 clinics and would have left the state with 1 provider instead of 5. And therefore the court found, well, the 4 justices who wrote the plurality opinion found that the health and safety benefits of this admitting privileges requirement, looking at all the evidence, again in front of the court, were clearly outweighed by the burdens on abortion access. But this was a plurality opinion. Only 4 justices joined in that proposition. Chief Justice Roberts provided the critical 5th vote to find the act unconstitutional, but the reason he concurred was that the Louisiana law imposes a burden on abortion access just as severe as that imposed by the Texas law, and for the same reasons. Essentially, we just decided this identical issue 4 years ago. The burden is just as severe in Louisiana as it was in Texas, and that's the end of the story for Chief Justice Roberts. Now, I'm going to come back to why this is significant, or we're going to talk next a bit about why this is significant, but so notice that Roberts only focuses on burdens and not benefits of the law. So there's more to what Chief Justice Roberts said. Again, he emphasized that the court should be concerned only with benefits, not with burdens, and the burdens must be substantial. And in so doing, he rejected the idea that whole woman's health required the court to look at the evidence of the benefits the law brought as well as of the burdens. He said the only thing we look at are burdens. And then he also essentially, I'm not going to go into detail, but he essentially engaged in a somewhat lukewarm embrace of stare decisis in this case, in following precedent, and said basically, yeah, we're following precedent because there's no reason not to here. He noted that no party asked the court to reconsider Planned Parenthood v. Casey, which of course lays out the current rule and the current protection for abortion rights, so that the court didn't have before it the question of whether essentially the right to abortion should be overruled. So if you're looking at this from the perspective of those who are in favor of abortion rights, as I am, you will find that on the one hand, there are things for pro-choice folks to be happy about. The Louisiana clinics got to stay open because the court struck down the law. Great. Roe v. Wade has not been overruled. There was some concern the court might even go there in that case. And the law really has not radically changed because of June Medical Services. Again, how long that's going to be true, we can talk about in a bit. But for now, the status quo remains. And this issue of third-party standing, which again could have been a bombshell, it fizzled instead, and it has probably been put to rest for a while. On the other hand, if you are pro-choice, there are reasons to be worried.
What?
There was no majority opinion in this case. Roberts's opinion, in fact,
I assume it's hanging on
respects,
going downstairs, or that or in your room.
Max, I can hear you. You should mute yourself.
What's going on now?
Roberts's opinion may, at least in some respects, be the controlling opinion because of something called the Marx rule that says when no single opinion has the agreement of 5 justices, the court looks at the position of those justices who agreed with the judgment on the narrowest grounds. And that would be Roberts. This certainly means that lawyers will be fighting over what the controlling law is for abortion restrictions now and whether June Medical Services has changed it. And it means ultimately lawyers are probably going to have to go back to showing the burdens on laws are significant enough to get them struck down without reference to the benefits. And finally, the other worrisome thing about June Medical Services from the pro-choice perspective is that Roberts did not signal super strong support for stare decisis in this context. Okay, I briefly want to talk on touch on what the other justices said. Each of the other conservatives on the court concurred separately as well, or sorry, dissented separately. They dissented, the 4 conservatives, other other than Roberts. Justice Thomas felt that there should be no third-party standing at all, that it's an illegitimate doctrine, and that the court should overrule Roe. Justice Alito felt that third-party standing may sometimes be okay, but that it was problematic here because of his theory that doctors have a conflict of interest with their patients in these cases. Again, I'm not going to go into detail unless folks want to talk about that. He agreed with Chief Justice Roberts that the court should not be balancing benefits and burdens. And he felt that this case was different in significant respects from the Texas case, and therefore that the admitting privileges requirement should go into effect. Similarly, Justice Gorsuch thought the court should have just let the law go into effect and then see what happens, that it was premature to strike it down. And then Justice Kavanaugh, okay, that's really Matt Damon as Justice Kavanaugh, but Justice Kavanaugh wrote separately in a very short dissent, but basically pointed out that today 5 members of the court reject the whole woman's health cost-benefit standard, the benefits burdens balancing test. So what does this mean moving from Louisiana to Ohio and beyond? What happened in June Medical Services? Well, nothing immediately or visibly changed as a result of this decision, right? However, if courts accept Roberts's view, it means that they will require plaintiffs to show an undue burden without consideration of whether the law has any medical or safety benefits. Why does that matter? Why is that significant for abortion restrictions? Well, the benefits of the law have to be shown by the state. So if the court doesn't look at the benefits, this really makes things easier for states. And where this really makes a difference is in cases where there's an abortion restriction that, you know, has no or negligible benefits. So the admitting privileges requirement is one example, but there are others too that are sort of passed for just pretextual reasons to shut down clinics or to make abortions harder to get, more expensive, more difficult, more unpleasant, but they really have no medical benefits. But they also don't have huge burdens. So if you think of the like light blue bucket there on the scale as being the benefits, if you have zero benefits or a feather on the benefit side, you don't need very much to outweigh it on the burden side. You don't need to show that half or 2/3 of the clinics in the state are shutting down. You can show, just that it's making abortion more expensive, more difficult to obtain, and you can get that law struck down. But if we don't look at benefits and we only look at burdens, then you're saying you have to really show something significant, like half, a third, who knows what the number is, but 2/3, something like that, of the clinics in the state are going to close because of this law. So, and I'm just going to talk briefly in terms of what sorts of litigation and legislation is currently out there across the country involving abortion restrictions that could be affected by this change. There are laws banning particular abortion methods, other sorts of what are called trap laws that target abortion clinics with unnecessary requirements, bans on telemedicine for medication only abortions. The outcomes of those cases could be affected because they are laws that tend not to entirely shut down clinics, but just have some sort of burdensome effect on abortion, but little or no medical benefit. On the other hand, other kinds of laws that we see across the country right now, early abortion bans like Ohio's 6-week abortion ban, the so-called heartbeat ban, or reason-based abortion bans that ban abortions for particular reasons like sex of the fetus or fetal anomaly. I think those are less likely to be affected by June Medical. However, they may be affected by the composition of the Supreme Court, assuming that Justice Ginsburg's vacancy is now filled by a conservative. It could have serious implications for the future of the abortion right in general. Again, we can talk about that during Q&A if you'd like. But what I want to do now is move on to Little Sisters of the Poor v. Pennsylvania, which was consolidated with Pennsylvania v. Trump, which are cases dealing with contraception. In particular, dealing with a challenge, the sort of saga of challenges, if you will, to the requirement that under the Affordable Care Act, that employers provide coverage for contraception in their insurance plans. And the most recent iteration of that saga involving the Trump administration's rule from 2017, granting a huge exemption on religious and moral grounds to employers who don't want to cover contraception. So what I'm going to talk about with this case, I'm going to start with a fair amount of background because it's really helpful to have that, I think, to understand what this case is really about and how we got there. And then I'll touch briefly on the implications as well. So first, just some general sort of statistics about contraceptives and coverage of contraceptives in the ACA. 99% of women of childbearing age who have ever had sex have used at least one contraceptive method. The vast majority of them use what's considered a highly effective contraceptive method, so sterilization, hormonal contraception, or IUD. And those are precisely the forms that are controversial from a religious perspective. And the numbers don't even really vary that much, as you can see, by religious identification. In the US, approximately 45% of pregnancies are unintended. And of those 45%, approximately 40% of those end in abortion. Contraceptive coverage has significant financial implications. So in 2009, before the Affordable Care Act, women of childbearing age paid approximately 68% more in out-of-pocket healthcare costs than men. And a big portion of that was due to contraception in particular. The Affordable Care Act, of course, signed into law by President Obama in 2010. As a result of the ACA, the median out-of-pocket expense for contraception was $0, and only 3% of insured women paid any out-of-pocket costs for contraception in 2015. and women were also more likely to choose more effective long-term methods of contraception. Okay, so that's the sort of statistics. Now I want to touch on some legal background just very quickly as well. Of course, we're probably all familiar with two key cases, Griswold v. Connecticut and Eisenstadt v. Baird, involving the constitutional right to use and distribute contraception, or recognizing that constitutional right. Of course, Roe v. Wade, 1973, which recognized a constitutional right to terminate a pregnancy. Immediately after Roe was decided, Congress adopted what was called the Church Amendments that provided for, in institutions that receive federal funds, that individuals cannot be forced to perform abortion or sterilization or discriminated against because they refuse. So immediately this sort of recognition of the conscience conflict, of the religious conflict with the reproductive rights, it was sort of present from the very beginning, right? And recognized immediately in 1973, as soon as Roe was decided. Okay, I'm going to fast forward a little bit, but in 1993, Congress adopted RFRA, the Religious Freedom, which was a law that applied to the federal government, or does now applies to the federal government, requiring an exemption from laws that substantially burden religious exercise. And some states have their own version of this law. So there is this federal protection for religious individuals, employers, and so on from federal laws that burden their religious exercise. Meanwhile, between 1999 and 2006, there was this huge movement in the states to adopt what are called contraceptive equity laws, requiring employers to cover contraception in their plans. Some of these laws had religious exemptions, others didn't, but about half the states adopted them during that time. Okay. Now I gotta see if I can advance this slide. Oh, there we go. Okay, in addition, both the EEOC and at least one federal district court around 2000, 2001, found that it actually violated Title VII not to provide contraceptive insurance coverage. So that it was sex discrimination in employment to cover other preventive medications, but not contraception. And as well, in this early 2000 time period, Catholic Charities, which is a Catholic nonprofit charitable organization, which operated in two states, New York and California, where there were contraceptive coverage mandates with a very narrow religious exemption that Catholic Charities did not qualify for. Catholic Charities litigated cases in the early 2000s challenging those narrow exemptions because they did not want to cover contraception, and they lost in both of those cases. The courts upheld the narrow exemptions. In addition, at the same time, there were attempts at the federal level as well to pass just a sort of freestanding, or to add it on to other existing legislation, contraceptives coverage requirement for employers. And these attempts repeatedly failed, largely because the two sides could not reach agreement over whether there should be a religious exemption, how broad, and what it should say. Okay, now this brings us up to date to 2010, where the saga of contraceptive coverage continues with, again, the Affordable Care Act. And this is where the immediate history of the Little Sisters of the Poor case kind of gets started. So 2010, Obama signs Affordable Care Act. It has language in it that requires coverage of preventive care for women, but it leaves it up to the agency, to HHS, and actually, so Department of Health and Human Services, and actually an agency within HHS called HRSA, to define exactly what is covered, what preventive care includes. This is, of course, a somewhat simplified version, but in 2011, the HRSA guidelines are released, and they say that what the Affordable Care Act requires is that you have to cover all FDA-approved forms of contraception. And it has only a very narrow exemption for religious employers, the same one actually that Catholic Charities was litigating over. And this is what is now referred to as the church exemption, because basically you had to be only a church could get, like an actual church, not just a religious nonprofit, could get the benefit of this exemption. Everybody else had to cover all FDA forms of contraception. And just to pause for a second, of course, that was religiously controversial, right? Not only because there were some employers who felt that certain forms of contraception should be considered abortion, that they were abortifacients. Emergency contraception, some kinds of IUDs are objected to by some religious individuals and employers. But also, the other issue is that, Catholic employers don't want to cover even birth control pills, right? Or other forms of prescription contraception because they are opposed in general to contraception. So all of these employers were arguing that the federal government was forcing them to violate their religious beliefs and be complicit in sin by covering these forms of contraception. So due to this uproar, there's a new accommodation, what was called an accommodation in 2012, 2013. Again, Obama administration adopted this accommodation for religious nonprofits, so broader than just churches, and said, you don't have to cover, if you are a nonprofit and you object on religious grounds to covering any or all forms of contraception, you don't have to cover them, but we are going to provide, you have to let us know you're going to do that, opt out, and then we are going to provide an alternative form of coverage for your employees. So you don't have to be complicit, but we're going to provide that coverage. Well, in 2014, Hobby Lobby litigates all the way up to the Supreme Court and challenges the fact that this accommodation only applies to nonprofits and not to for-profit corporations. Hobby Lobby claims that this violates RFRA, the Religious Freedom Restoration Act, and wins and gets the advantage of the accommodation. However, the fight continues even after Hobby Lobby because the nonprofits actually claim that they don't like the accommodation they've been given, that the requirement of making this certification of opting out also burdens their religion because it's the act that triggers the contraceptive coverage, and therefore they are still complicit in contraception. Basically what happens after this is the case goes up to the Supreme Court in Zubik v. Burwell 2016, and the parties essentially fight to a draw. The Supreme Court says, you're both, you need to work it out. We're not going to decide. You need to provide coverage while also protecting religious exercise. See if you can work it out. The parties say, essentially, we can't work it out. They cannot reach an agreement on how to accommodate both interests. And this brings us to 2017 and the Trump administration. So what happens? The Trump administration comes in, and in October 2017 adopts a new rule regarding coverage of contraception under the ACA. So starting from scratch, if you will. This is important. They do this through a sort of what you might consider almost like an emergency process by adopting an interim final rule rather than going through the traditional notice and comment process of rulemaking. So they adopt this interim final rule that's effective immediately, that says almost any employer, nonprofit, for-profit, publicly traded, any employer can opt out for almost any reason, religious or moral reason. So I don't know what other reason there might be, but religious or moral reason from providing contraception. The only exception to this is that if you're a publicly traded company, you can only opt out for a religious reason, not a moral reason. There's no requirement of advance notice or of providing alternative coverage. They can allow their employees to access coverage through alternative means, but are not required to. And that these also apply to student health plans. So this is the rule that is now challenged in Little Sisters of the Poor v. Pennsylvania. So whereas the prior lawsuits were religious employers saying the Obama administration's rule and its exemption is too narrow and it's burdening our religious beliefs, this is now the state of Pennsylvania, and then joined by New Jersey, actually, suing the Trump administration and saying this rule is too big an opt-out. It violates the Administrative Procedure Act, and they claimed that they were harmed, that the states were harmed. They had standing because it was basically it was creating such a gap in coverage, it was going to end up imposing costs on the states' programs to cover contraception and family planning services. So, so the states of Pennsylvania and New Jersey sued the Trump administration, said this rule has too broad an opt-out. It violates the Administrative Procedure Act. The Little Sisters of the Poor intervened on the government side, and that's why the case is named after them. Okay. So Pennsylvania and New Jersey argued Trump administration violates the APA. Supreme Court ultimately rules no, the Trump administration rule did not violate the APA. So I'm going to go through the somewhat technical arguments, legal arguments in this case, again, in somewhat simplified form, and then briefly touch on the implications, and then I'll stop talking. Okay, so first, Pennsylvania and New Jersey argued that using this kind of emergency interim final rule process, rather than the typical notice and comment process, without good cause for doing so, violated the APA. Because you can do this, but you can use this interim final rule process, but you were supposed to have good cause. And the states alleged there was no good cause. The Supreme Court said, you know, in the end, you had this interim final rule, but then you ultimately had an actual final rule adopted after a period of notice and comment. So that is what happened. There was initially the interim final rule that was challenged, but then much time elapsed. There was a period of notice and comment. The administration then adopted a final rule. The court said, you know, potato, potato, same thing. You got your opportunity for notice and comment. So, you know, we're really not going to consider this procedural objection, or we consider it irrelevant. Pennsylvania and New Jersey also argued that the administration showed no real openness to comments between the interim final rule and the final rule, so that this notice and comment period that did exist it was meaningless. It didn't cure this defect because there was no real meaningful opportunity to comment. The final rule was in all meaningful respects identical to the interim initial rule. SCOTUS said, oh, and by the way, this was a 7-2 decision. I'll talk about that in a minute. 7-2 decision. Justice Thomas wrote the opinion. He said, there's no open-mindedness requirement in the APA. You had your notice and comment period, no procedural defect. Okay, well then New Jersey and Pennsylvania also argued that this broad religious exemption contravenes the statute's mandate. And in particular, what they were saying was that the statute actually said that employers had to cover preventive health care as provided for in comprehensive guidelines supported by HRSA. And the states argued that what this means was that HRSA had a mandate to decide what services were covered, but did not have discretion to just decide who had to provide those contraceptive services, who had to provide that insurance. HRSA could only say what forms of contraception were covered. So in other words, that HRSA went beyond the discretion given to it by the statute. And that the statute clearly intended for, you know, not to have such a broad opt-out. The Supreme Court said, no, the statute language is very broad. It's a broad delegation of authority to the agency, including authority to make exemptions from its mandate. And, you know, admittedly, I have to say the language was pretty unclear, I think, in that respect. So it seems to me a reasonable thing to say, to decide that the statute did delegate that authority. The states also argued that RFRA does not require this exemption. So this was one of the administration's arguments for adopting this broad sweeping exemption. Almost anybody can opt out for any religious or moral reasons. The state said, look, there was already this accommodation system in place. It was perfectly fine under RFRA. It didn't violate anyone's religious freedom. The RFRA did not require taking this additional step. And so it's not a basis to justify what the administration did. The Supreme Court did not decide that question, felt it did not need to, but did think it was appropriate for the agency to consider RFRA and to consider whether RFRA required it to take these steps. Justice Alito, joined by Justice Gorsuch, actually concurred separately to say he thought this broad exemption, at least on the religion side, maybe not the moral side, but the religious exemption side, was required by RFRA. Finally, Pennsylvania and New Jersey said this rule is substantively arbitrary and capricious and therefore violates the APA on that separate ground because it is not justified by the statute, and that it does not address, it's overbroad, and it does not really address any problem that needed to be solved. We already had a system in place. There was no need for this rule. It's not justified by the agency. And SCOTUS said, we're not going to decide this if it's substantively arbitrary and capricious. So that claim is still alive, and that claim remains to be decided by the lower court. So here, to summarize, it was a 7-2 decision. The only two justices who actually dissented were Ginsburg and Sotomayor. However, Breyer and Kagan wrote separately, Justice Kagan, joined by Justice Breyer, wrote separately to say that she thought the rule probably was, or those two thought the rule probably was substantively arbitrary and capricious. So that challenge should continue and should probably succeed because of the terrible mismatch between this supposed problem of violating employers' religious rights and the solution of this broad sweeping exemption with no alternative coverage provided for the employees. Okay, so what is the impact of this briefly likely to be? Well, a study from 2015, so before all of this litigation, said that 10% of nonprofits with 1,000 or more employees had elected this accommodation. So now they can opt out completely and not insure, there's no insurance that their employees will get alternative coverage. So there's every reason to think many of those employees are going to lose coverage altogether. Increasing number, a study also indicated that an increasing number of for-profit employers were seeking exemptions. The government estimates itself that it's between 70,500 and 126,400 women would lose coverage under the new rule. And this might be an underestimate because of how the government counted. In 2017, the average out-of-pocket cost of contraception without insurance is $850 a year, which is a really enormous amount for somebody who is surviving on a very low income. And not all low-income individuals have access to publicly funded programs to give them access to family planning, both because of how those programs are funded or are structured, and because of cutbacks as well in the funding of those programs. Of course, we can talk more about this, but so thank you for listening to that long discussion. And I am interested in now seeing if there are questions. Let's see. So Anne Flam, did unintended pregnancy and abortion rates decline as contraceptive coverage increased under the ACA? That is a good question. Abortion rates have certainly declined significantly in the past 10 years. I believe unintended pregnancy rates did as well. It's always kind of hard to say exactly with such a major number, sort of with so many causal factors, what actually caused it. But there's a lot of evidence to suggest that a huge factor was the ACA, and particularly the fact that under the Affordable Care Act, women could get access to long-acting contraceptive methods, including the IUD, that you have it inserted, it lasts 5 or 10 years, you never have to think about it. Before the ACA, that was financially out of reach for a lot of women because the upfront cost of an IUD on average is about $1,300. So a lot of people who didn't have insurance didn't have access. After the ACA, they did, and there's a lot of belief that it's called LARC, long-acting reversible contraceptive methods, take a lot of the credit for that, fall in unintended pregnancy and abortion rates. So regarding the issue, someone asked, regarding the issue of pretextual laws from a pro-choice perspective, can you think of any currently enacted, valid, non-pretextual health and safety laws which you feel are not overly burdensome and at heart are not anti-choice? So that's a really broad question. Thank you for that question. I think, but I mean, there's a potentially, or broad question, there's potentially a lot of answers to that question. I think there are laws that affect abortion providers that are in effect currently that surely are valid health and safety restrictions. So, you know, requirements that abortions be provided by qualified professionals, certain, you know, requirements around the I don't know, health and you know, sanitation standards, for example, for abortion clinics, disposal, you know, tissue disposal requirements and so on that are currently in effect. So abortion is one of the most heavily regulated medical procedures, you know, if not the most heavily regulated medical procedure. And many of those regulations, yeah, I think don't get challenged, are not necessarily pretextual, are real. You know, I also think this is not exactly a health and safety regulation, but for example, there's a law that requires genetic counselors and physicians who give a patient a diagnosis of fetal Down syndrome. So if they find out that the fetus they're carrying has Down syndrome, requires certain information and referrals to be given about Down syndrome so that the patient, you know, has the full picture and can get accurate information about what that means so that they don't, you know, I think in an effort to counter maybe, you know, fear-based decisions about terminating a pregnancy and things like that. Again, I don't have any particular objection to that, and I think those would not be found either pretextual or unconstitutional. Okay, so I have a question that I don't understand here in the chat about conferring with the original judge you're about to overrule. But if you want to clarify that question, otherwise I don't think I understand what you're asking about. It's okay. Okay, so let me see, I have another question here. If Roe v. Wade is overturned, do you think regulation of abortion will be left to individual states? And if so, which states are the most protective of the right to an abortion? Yes, if Roe v. Wade is overturned, I do think that the way the court would do it would be to say there's no federal constitutional right to an abortion, but individual states can decide whether to permit abortions. And if that were to happen, Ohio is, at least the current political climate in Ohio is very hostile to abortion rights. So Ohio would not be a state that would be likely to protect the right to abortion, again, as the General Assembly and executive branch are composed right now. The most protective ones are pretty much probably the exact ones you would guess. They're the blue states. They're the ones on the coast primarily, plus like Illinois. You know, the more hostile ones are the Midwestern and Southern states. You can actually go on, I think, it might be the Center for Reproductive Rights, that a national organization that has a map that sort of suggests which states would be likely to enact, you know, immediate severe abortion restrictions in the wake of Roe, but it's pretty much would break down, it seems to me, on the political lines, as you would expect. Oh, I had a question about the prescription coverage requirement. Was there a corresponding refusal to cover male impotency treatment, male, I guess, erectile dysfunction treatment prescriptions? I have never heard of any employer refusing to cover that on religious grounds. But I will say that one of the big, if in my lecture, you probably picked up, there was this big flurry of sort of activity around the year 2000, late 90s, early 2000s. And part of what was going on was that Viagra had been approved by the FDA a little bit before that. And as soon as it was approved, almost immediately insurers jumped to cover it. And health insurers jumped to cover it. And they still, many of them were not covering contraception. And for a lot of women, although there wasn't really a legal argument there, for a lot of women that really, like, the hypocrisy kind of hit home, that like there's this drug that's only for men and insurance companies jump to cover it, and then there's these drugs that are only for women, and that it wasn't covered by insurers. So okay. No, and there was no, oh, I see, there's a clarification. No, I don't know of any refusal by Hobby Lobby or any other religious employer to cover those kinds of drugs. I just don't know what I said. I have this kind of repeated clarification here about conferring with the original judge you're about to overrule. I don't remember saying anything about conferring with a judge someone's about to overrule, but I just maybe I misspoke about something, or I'm sorry. That question I don't understand. If you'd like to contact me offline, I can put my email address in this chat as well. Don't ask me questions about CLE. The person to ask about CLE is Patty Harbold, P as in Patty, M as in, I don't know, Mary, K, 10, the number 10 at case.edu, PMK10 at case.edu. She's the person to contact about CLE. My email is in the chat if you want to contact me with substantive questions about the presentation. Okay, I have another question. Did Hobby Lobby's insurance rates actually increase based on the requirement to cover birth control? Or was there evidence to that effect, or was there a decrease after the requirement was struck? So was there evidence that Hobby Lobby itself is actually bearing the burden of covering it? No, so that's a very interesting thing, because actually coverage of contraception has proven to be cost effective. And so it rarely costs the employer anything, and usually actually saves the employer money because of the reduction in unintended pregnancies after the, when the contraception is covered. So it's one of these things that it's really almost never a financial decision, or it's not a sensible one by an employer, because generally the cost of covering contraception is zero, actually. So no, there was no cost differential. It was just the fact of having to have that provision in the insurance plans. Oh, and I always get this question, and it's a great one. So there's a question: do restrictions cover oral contraceptives that are prescribed for non-contraceptive uses, like hormonal changes at menopause or certain other conditions? There can be like cysts and things like that, where people are prescribed oral contraceptives because of the hormones for medical conditions and not for contraceptive purposes. So my understanding is that employers, even religious employers, will still cover them for those purposes. And again, it's my understanding that the plans will still cover them for those purposes. I don't know in reality how that plays out. So I don't know in reality, I just don't have enough access to this information about whether individuals are getting those claims covered, whether they're making those kinds of claims and getting them covered by their insurance, or whether there's, when the plans don't cover contraceptives for one reason, that they'll cover them for another reason. But my understanding is actually that those, at least in theory, those uses of oral contraception should be still provided under the plan because they are, quote unquote, therapeutic in a way that family planning is not.